Assalamualaikum warahmatullahi wabarakatuh. Good evening, ladies and gentlemen. It is my pleasure to welcome you to Raising Awareness Succession and Programs. Today, we are from Group 19 will bring to you a discussion regarding Privilege Wills under Wills Act 1959. Do you know that this will is specially designed for our nation heroes? Those who combat with bravery just to sustain peace and serenity in our beloved Malaysia. Wouldn't you like to explore more regarding this topic? Therefore, we, the members of Group 19, brings to you an expert to lead our discussion tonight. Without further delay, let us introduce our honourable guest. I think Mia is exuberant to introduce our guest. Would you please join us in welcoming our honourable guest, Dr. Faridah?
Okay, thank you, Anwar. Assalamualaikum and good evening, ladies and gentlemen. My name is Nur Namira Sharifuddin, but tonight you guys can call me Mia. We are from Group 19 for East Sulam Project, or our firm name known as Shima Shana & Co. In the next hour with us, you guys will learn about privilege wheels from our honourable speaker. Without further ado, I am going to introduce you guys for our speaker tonight, which is Dr. Faridah binti Hussain, or known as Dr. Faridah. She practiced advocates and solicitors starting from the year 1993 until 2009, which makes her working experience of 16 years altogether. However, despite her busy schedule, she did her part-time as lecturer in University Selangor during the year 2005 until 2009. Well, I guess that made her genuinely enjoy being a lecturer. So she continues their career as a lecturer in Faculty of Law, UiTM Shah from the year 2009 until now. Okay, Anwar, you can continue from here.
All right. Thank you, Mia. Dr. Faridah pursued her first higher education in Mara Technology Institute. After she secured her first diploma in law, she obtained her advanced diploma in law from the same alma mater. Later, she received Master of Law (LLM) from University Malaya. In 2019, she finished her doctorate at International Islamic University of Malaya. She wrote a thesis regarding the application of privilege wills in Malaysia and other selected countries, a comparative analysis. Hence, we believe that Dr. Faridah is the best choice to be invited as our guest this evening.
Alright, Anwar, without waiting any longer, let's meet with our speaker for tonight. Assalamualaikum, Doctor. How are you feeling today? All good?
Waalaikumsalam.
Alright, before we
yes,
start,
Alhamdulillah. Thank you for inviting me to this program.
Oh, no. Thank you for
Can you hear me?
Yeah, we can. Okay. Anwar, can you start?
All right, Mia. As a matter of priority, let me start the discussion with the first question, shall we? Okay, Dr. Faridah. Most of us are inquisitive. What is privilege wills? Would you please ease our inquiry?
Okay. Assalamualaikum and evening to everyone, ladies and gentlemen Malaysia. To begin with blessing from God, I will start with Bismillahirrahmanirrahim. Ya, Allahumma salli ala Muhammad wa ala ali Muhammad. Rabbis rohli sadri wa yashir li amri wahlul uqdatan min lisani yafqahu qawli. May Allah subhanahu wa ta'ala bless us all in seeking knowledge. Firstly, I would like to express my appreciation to the University Utara Malaysia through their Sulam project handled by LLB students of UUM Group 19. Thank you for inviting me to this program. Okay, regarding the question that the moderator asked just now, what is a privilege will? Okay, let me share with ladies and gentlemen. The Wills Act 1959, Section 26 sub 2 provides that a privilege will means any declaration or disposition, oral or in writing, made by or at the directions of the testator, which manifests the intentions of the testator which he desires to be carried. These include his desire to the guardianship, custody, and tuition of a child, or to the exercise of a power of appointment. If I may simplify to ladies and gentlemen, privilege will is a declaration, or disposition made by the testator. The testator means a person who is making a will. All right, and this is the meaning that it is a declaration. Declaration on what? Declaration on how he may dispose his property, declaration on whether he desires to dispose about the matters about the guardianship of his children, custody and tuition of a child. He may also exercise power of appointment by way of declaration or disposition. And Section 26 sub 2 specifically provides that that the privilege will may be made either in oral or in writing. This is the characteristic, the special characteristic of a privilege will. If I may explain in bahasa Malaysia, privilege wills mean wasiat terlindung. So you may not, some of us may not familiar is not familiar with the meaning of privilege will. So we will discuss in detail why the term is called privilege will. That is for question number 1. Back to the moderator.
I see. Thank you. That's very good answer to start the night tonight, Doctor. I think not everyone knows what is actually privilege will. Maybe some of them just familiar with will, just will, normal will. So shall we move on to the next question, Doctor? Okay.
Yes, please.
Second question for tonight is there any difference between a privilege will and a normal will?
Okay. This is a very special question. People may ask why there are two terms. One is normal will, one is privilege will. Okay, if you look at the provision under the Wills Act 1959, especially when you refer to Section 26 sub 2, it provides that a privilege will may be made in oral or in writing. Meaning to say, the testator can make a privilege will either in writing or he can orally make the privilege will. As to the contrary, on the opposite, on the other hand, we have Section 5 sub 1 under the Wills Act 1959, where it specifically provides that no will shall be valid unless it is in writing. Okay, this is the first difference between a normal will and a privilege will. In a normal will, the will is not valid unless it is made in writing. However, if a person, a testator make a privilege will, the testator can make an oral will under the privilege will. Okay, the second differences between the normal will and privilege will is that the provision laid under the Section 4, 5, and 6 of the Wills Act will not be applicable for the privilege will. These we may find the provision of law under Section 26 sub 4 of the Wills Act 1959. So if you look at Section 4 of the Wills Act 1959, it mentioned about will of an infant as invalid. However, for privileged will, an infant testator can make a will. So this is the second difference. The difference. We can see the difference number 2. Number 3. It is about the mode of execution of will. For a normal will, you have under the Wills Act, we find that a will has to be made in writing before 2 witnesses. However, for privileged will, it can be made either oral, it can also be made in writing, it can also be made in before only 1 witness. We have many cases illustrates on this. So these are the differences between a normal will and a privileged will. That is the answer to the second question. Yes, back to moderator.
All right. Thanks for your explanation regarding the differences between normal wills and privileged will. My second question is, who can make privileged wills?
Okay. On the question, who can make a privileged will? This is also very interesting, because we have a special law on who can make a privileged will. The Wills Act 1959, Section 26 sub 1 provides that a member of the armed forces of Malaysia being in actual military service. The word here, a member of the armed forces of Malaysia being in actual military service. That is number 1. Number 2, a mariner or seaman, including members of the naval forces of Malaysia. A mariner or seaman, including members of the naval forces of Malaysia. The word here, being at sea. Being at sea. Only this group can dispose of their property or can make a provision regarding guardianship, custody, and tuition of a child, or they may exercise a power of appointment, exercisable by will, by making a privileged will. So if I may explain in bahasa Malaysia, di bawah Section 26 kurungan 1 dari Akta Wasiat 1959 memperuntukkan hanya members of the armed forces of Malaysia, maksudnya tentera darat Malaysia, di Malaysia, being in actual military service. If we may translate in bahasa, it means that yang benar-benar berada di dalam ketenteraan. So that is the meaning. I tried to look for the terms and I found this term in the Armed Forces Act 1972. What is the meaning of actual military service? If we may translate in bahasa, it means yang benar-benar berada di dalam ketenteraan. So they can make a privileged will. Even normal soldiers, they cannot make a privileged will. They can only make a privileged will or soldier's will when they are in actual military service. That is the meaning. First, who can make a privileged will. The second thing is this Section 26 sub 1 tell us that the second category of profession who can make a privileged will is the mariners or seamen. If we may translate bermaknanya seorang pelaut ataupun kelasi. So this mariners or seamen if we look at the decided cases, means a person who is being at sea although they are in merchant ship ataupun yang berada di dalam pelayar atau pelaut yang membawa kapal dagang And also this Wills Act 1959 says it is including members of the naval forces of Malaysia, meaning to say termasuklah juga tentera-tentera laut yang sedang di dalam ketenteraan. If you go through many decided cases, it also includes the members of the naval forces, meaning to say Kalau saya boleh terangkan dalam bahasa Melayu ya, ini termasuk juga tentera-tentera udara ya. Jadi only this category of people ya, they are privileged ya. They can make a privilege will. Mereka ini ya, apabila membuat wasiat semasa mereka berada dalam ketenteraan ataupun berada di lautan, wasiat mereka adalah terlindung. Walaupun wasiat itu tidak dibuat secara formal, ia masih tetap dianggap sebagai satu wasiat. Itulah privilege will. Their will is privilege. Yeah, so you may find that I may explain in English and also in bahasa, so that I hope that ladies and gentlemen, especially the students here, they understand what is the meaning of privilege will. Okay, that is the. I hope I have answered your question here. Who can make a privilege wills? Back to the moderator.
Okay. Thank you, Doctor.
Yeah.
All right. Now, I believe that everyone knows that not everyone can make privilege will. It only applies to naval forces, military service, that is dalam bahasa Melayu, dalam dia tengah buat ketenteraan. Bukan soldier biasa saja. Okay. To the fourth question for tonight is how to make a privilege will. What exactly the procedures? Is it hard and complicated?
Yeah. Okay. How to make a privilege will? Yeah. We may find the provision of law under Section 26 sub 3 of the Wills Act 1959. If we go through Section 26 sub 3 of the Wills Act 1959, it provides that a declaration may be a valid privilege will. Yeah, notwithstanding that it was not executed in the manner appearing to have been intended by the testator, or that it was intended by the testator subsequently to execute a formal will to give effect to his testamentary dispositions, unless it appears to his testamentary disposition, unless it appears that the failure to execute such declaration in such manner or such formal will was due to the abandonment by the testator of the testamentary intentions expressed by such declaration. If you read this provision here, it tells us that the declaration here may be a valid privilege will. So how a testator, the soldiers in actual military service, or on how sailors being at sea, they can make a privilege will. They can make a privilege will either orally, or they can make a privilege will by way of declaration, and also by writing. So these are the way on how a privilege will can be made. If we go through the decided cases and also the literature review about this privilege will, we may see that the law recognize if soldiers in actual military service, they do not have paper or pen to make a will, their last will and testament, they can also use their blood to write in any material to express their last intention. That also has been recognized by a law as the last will and testament of the testator. That is for the soldiers in actual military service or sailors being at sea. Jadi mereka-mereka yang tentera tentera darat, tentera laut, tentera udara yang benar-benar dalam ketenteraan, serta pelaut dan kelasi yang berada di lautan, wasiat mereka jikalaupun tidak formal tetapi mahkamah mengambil kira wasiat itu sebagai sah dan wasiat itu adalah dilindungi oleh undang-undang. So that is the meaning or meaning to say in a simple term, they can make a will informal. Wasiat untuk golongan yang istimewa ini yang mempertahankan negara ini, wasiat mereka adalah dianggap terlindung dilindungi oleh undang-undang. They are privileged. This is how privilege will can be made. It is not it can be made as formally, it can also be made informal. That is the answer on how to make a privilege wills. Yes, back to the moderator.
Much obliged to Faridah. Now, we know that how to conduct a privilege will. Okay, let us move on to the next question. Before this, you said that personnel who is in active military can execute this will, right? My question is, when
Yes.
a soldier in actual military service can make a privilege will?
Also a very interesting point, yeah, because ladies and gentlemen, yeah, when I did my PhD on the topic of privilege will, I tried to look for Malaysian cases. Unfortunately, we have limitation. We do not have any decided cases on privilege will. As such, I have to refer to the common law cases, especially from the United Kingdom. So through my research, I found that the meaning of actual military service. What is the meaning of actual military service under the law? So I would like to share that the rules governing the proper test for what is actual military service was laid down in a well-known case, that is in the case of Court of Appeal, in the case of Wingham deceased, Andrew and another versus Wingham. This case was decided in 1948 to All England Report 908, where in this case, the court decided that, read of this, if I may read the important provision of the judgment. Read of this Roman test, this court has to decide what is the proper test for actual military service. It must be both simple and certain simple, because it is to be understood by all ranks, and certain because every soldier must be able to apply it without difficulty in the situation in which he finds himself. It is quite beside the mark to inquire what are the reasons for the privilege. The privilege is one thing. The reason for it is another thing. The reasons are no doubt that a soldier in actual military service is likely to be in danger or to be left off legal advice. It would be a great mistake, however, to argue therefrom that a soldier who is not in danger or who has legal advice at his elbow cannot make a soldier's will. This would be to confound the reasons for the rule with the rule itself. The rule is that a soldier in actual military service is privileged to make a will without any formalities. For this case, in the same appeal case, Cohen LJ, in the same case, in the case of Wingham, decided in 1948, mentioned that the privilege conferred by Section 11 of the Wills Act 1837 for the UK English Wills Act does not extend to all regular soldiers at all time, but only to soldiers who are in expedition. So ladies and gentlemen, from this test for the actual military service that has been decided by the court, we come to the knowledge that not all regular soldiers at any time, at all time, can make a privilege will. They must be in the actual military service. Example, they are in expedition. For example, they receive a command from the government, to be sent to another country to for a duty. As such, they are considered. For example, if they go from his place, from his place, or his station to the other country, the law assume that they are in expedition. As such, they can make a privilege will. This is the test laid by the court in the case of Wingham. And also, ladies and gentlemen, from this judgment, we can infer that all ranks of soldiers in actual military service has to be likely in danger, yeah, and to be bereft of legal advice. Yeah, in a simple term, yeah, the law recognized that once a soldier has received a command, yeah, to perform a duty for the country, the law recognized that they are in danger, yeah, and the law also recognized that they have left with no legal advice on how to make a disposition about their property. As such, they are privileged, yeah, they can make a privilege will. So if I can simplify, in the other words, the rule is that, yeah, a soldier who is in actual military service is privileged to make a will without any formalities. Yeah, so this is quite a settled law on privileged will. Yeah, that the key word is that they are in expedition, yeah, or they are mobilized. So coming back to the meaning of what is the meaning of actual military service, yeah, this is the test laid down by the English court, yeah, that is from the UK. Okay, I would like to explain a bit, yeah, in detail about the meaning, yeah, of actual military service. Yeah, the court also, yeah, if we look at the one decided case, yeah, the case in the estate of Coleman, yeah, decided in 1958 to All England Report 35, yeah, the court held that in determining the issue as to whether the deceased was in actual military service, yeah, the court applied the test laid down by the decision of the Court of Appeal in Rewingham, yeah, wherein Bucknell LJ dealt as to the meaning of actual military service. From the decided cases, we may find that, yeah, we may see the case illustrates, yeah, about facts of soldiers, yeah, in that case, and how the court determined, yeah, the test for the actual military service, or is if the issue raised, yeah, in the application for probate, where the beneficiaries, yeah, contest about the existence of the privilege will, the court will use the test that is laid down in the case of Rewingham versus Rewingham and Rule versus Wingham. So this is the meaning, yeah. If you are interested to know in detail what is the meaning of actual military service, I would advise, yes, students and ladies and gentlemen to read this landmark case, yeah, on privilege will. So that is the answer, yeah. Back to the moderator.
Thank you, Dr. Faridah.
Yeah.
That is actually very interesting. And actually, the question just now relates with the next question, Doctor. So, how about the sailor, Doctor? Can they make privilege wills while being at the sea?
Okay. Okay. Just now, yeah, we talk about a special privileged group that is soldiers. Yeah, soldiers include members of the naval forces. It also includes, yeah, naval forces, yeah, and also the airmen, yeah. Maksudnya, ya, kalau tadi, ya, untuk tentera laut, tentera darat dan tentera udara, ya. So now tadi, ya, untuk tentera laut, tentera udara dan tentera darat, ya. So okay, now section 26, ya, sub 1 of the Wills Act 1959 mentions specifically the words, yeah, that a member of the Armed Forces of Malaysia being in actual military service and a mariner, yeah, or seaman, including a member of the Naval Forces of Malaysia being at sea. The keyword here is being at sea. Yeah, the keyword here is a member of the Naval Forces of Malaysia, ya, a mariner or seaman being at sea. Maknanya, ya, kalau saya boleh minta izin, ya, kalau saya boleh sebut dalam bahasa Malaysia, pelaut dan kelasi, ya, termasuklah tentera tentera laut, ya, yang berada di lautan. So this is the words, ya. So how do we know, ya, what is the meaning of a sailor being at sea? In order to answer this, we have to read decided cases also, yeah, where we have limitation. We do not have decided cases in Malaysia yet. However, yeah, if we visit the cases from the United Kingdom, yeah, we may find many cases on the privilege will, especially the involved, yeah, sailors, yeah. So from many decided cases, the term sailors, yeah, include mariner and seamen. Okay, it applies from the from one decided cases, yeah, it applies from the commander-in-chief to a common seaman. Yeah. For example, if you read the cases here, in the Goods of Richard Hayes Disease, decided in 1839, yeah, so the court held that, yeah, sailors include mariners and seamen, yeah. So if you the court, yeah, has also decided, yeah, in the case of in the Goods of Daniel Saunders, yeah, this case was decided in 1865, where the court held that, yeah, sailors also include a surgeon in a navy, ya, maksudnya doktor ya yang berada atau bertugas di tentera laut, ya, di kapal ya, mereka juga ada layak untuk membuat, they are considered as sailors being at sea, ya, maksudnya berada di lautan, ya. So also, ya, class, if you we have the court also has decided, yeah, in the case of relay, yeah, this case was decided in 1840, yeah, where the court held that a ship canal pilot is considered a mariners, a sailors being at sea. Okay, we also have the cases, yeah, decided cases, the case of in the estate of W.C. Yeats deceased. This case was decided in 1919. Yeah? The court held that a lieutenant in the Royal Navy is considered also as sailors being at sea. Excuse me. We also have a case, yeah, one decided case. The case name here is Caroline Margaret Bernard plaintiff, yeah, versus this case, yeah, decided also, in 1919 also, yeah, where the court held, yeah, that a captain, yeah, a captain of a steamer, yeah, they are also considered as sailors being at sea. A marine engineer also can be considered as sailors being at sea, as decided in the case of Re Godfrey. This case was decided in 1908. And also the court held that a sailor, ya, sailor, kalau dalam bahasa Melayu, ya, pelayar, kan, pelaut, ya, sailor, ya, they are also be considered, ya, falls under the category of sailors being at sea. This was decided in the case of in the will of Desmond, decided in 1921. Yeah, as such, I may share with ladies and gentlemen that it is established that a seaman includes a master of merchant vessels. Yeah? The court held that a seaman, yeah, includes a master of merchant's vessel in the case of in Re Milligan. This case of Re Milligan, yeah, was the is an old case, yeah, where involved, yeah, a sailors being at sea. If I may explain in bahasa, ya, pelaut yang membawa kapal dagang, ya, mereka juga boleh dikatakan pelaut, ya, yang berada di lautan, dan mereka boleh membuat wasiat, ya, dan wasiat mereka adalah terlindung, ya. So we have many interesting case, ya, on this point of who is a sailor, ya. Also, ya, class, in 1952, yeah, we have a case, yeah, decided by the court, the case of in the Goods of Alfred John Wilson, yeah, versus Clough, yeah, where the court held that a chief officer in the merchant navy who made a will in contemplation of sailing is privileged. ya, maksudnya ya pelaut-pelaut yang baru ya bergerak dari satu ke tempatnya ke lautan ya, mereka adalah boleh membuat wasiat secara informal ya, they are privileged ya. Also ya class, in 1952 the court decided ya, in the case of estate of new land that the court held ya, an apprentice in the employ of a steamship company, they are considered sailors yeah, being at sea, they are privileged. So if you like yeah, if you have an interest yeah, in reading the interesting case on this privilege wheel, you may find so many cases yeah, decided from the 100 years yeah, more than 300 years ago yeah, on this privilege wheel. As such it is very interesting where the court yeah, recognize this category of profession yeah, they are privileged because the court recognized their contribution to the country. So we may see our Wills Act 1959, Section 26, yeah, provides specifically on the provision of privileged wills for soldiers, airmen, and sailors. If I may add one point, yeah, for the information of ladies and gentlemen, yeah, we have this Wills Act 1959. Yes.
Doctor, we can't hear you.
Non-Muslim. Yeah?
Wait for a while, guys.
This is the point that we have to note, yeah, to take note. Yeah? And I also, in my research, yeah, in my PhD research, I have recommended yeah, that the same provision also should be applicable to Muslim soldiers yeah, and Muslim sailors. Including members of the naval forces, because they also share the same responsibility with their non-Muslim brothers, yeah, who are also soldiers. They protect the country, yeah, so they should be privileged also, their will, yeah. So this is point yeah, that I would like to share with the audience. Okay, that is my answer. Yeah, I have so many cases yeah, on sailors being at sea, or who are sailors being at sea, who are the considered yeah, soldiers in actual military service. Unfortunately, I cannot share everything yeah, in 1 hour. Maybe if you are interested, you can contact me later yeah, on. Yeah, okay. To the moderator.
All right. Thank you, Dr. Faridah. It is crystallized now that a sailor can be aware during being at the sea. If I may know, in your point of view, does privilege rules is relevant in Malaysia?
Okay. Okay, this question is very interesting. Yeah, whether privilege will yeah, is still relevant. Yeah, in my personal opinion, yeah, the privilege will is still relevant. Yeah, because we have to protect yeah the soldiers. Yeah, and also the will made by the soldiers in actual military service. Yeah, because they protect the country. Yeah, they have no chance. Yeah, if they receive the command from the government to serve for the country, they have to perform yeah, the command on the spot. As such, they may have no time to contact a lawyer. They may have no time to make a disposition about the statement of affairs of their properties. As such, they are privileged. And this is an old law where the law also recognizes on the privilege will is to be given to the special category of profession, especially soldiers in actual military service, sailors, and also mariners and seamen, including members of the naval forces of Malaysia. Um, Without this category of people, we may not be able to enjoy the peace, and also they are the heroes, for our countries. We have to protect their affairs, especially when they want to deal with their property in a very difficult situation. We have to imagine, they are in war, for example, they don't have pen or they don't have pencil, for example, they may also find difficulty to contact a lawyer, on how to dispose their property. They may also have difficulty, if they uh, they suffer injury, for example, so we can imagine, that they are really in a very hard and difficult situation. They have to protect their country. They have to make sure, they are safe in actual military service, and they have families, left behind. They may have wife, they may have a husband. If the female soldier, they may have children, minor, for example. As such, if they want to dispose their property, by way of will, their will must be privileged. As such, the law, on the privilege will is very relevant, in this contemporary time, especially in the year of 2020. We may not know that a war may happen, so that is the answer to the question. Back to the moderator.
All right, thank you, Doctor. That means privileged will is still relevant in Malaysia. In my own opinion, I also still believe that we need this privileged will as we need to give back to the soldiers that sacrifice for us for the country. Okay, guys, we have finished the question for tonight, but we are going to choose two questions from the comment section. So we have to wait for one of our group mate to choose the question. Anwar, do you want to start? What's the question?
All right, let us choose the question from the
Yeah.
comment section. Uh, okay, the first question is from Lily Nies. I have a question for Dr. Faridah. What if the testator made an oral will in front of two of his friends, A and B, but only A clearly heard his word, his intention, etc. B heard only say 40% of the oral will. Then the testator and his friend A died in service. So B only managed to make up 40% of the oral will. What will happen to the rest of his property? Okay, doctor. What is your point of view regarding Lily's question?
Okay, very interesting question. If I can read again, the oral will in front of two of his friend A and B. I guess, this question, this testator is a soldiers, in actual military service. So topic only A clearly heard his voice, his intention, etc. Okay, now we see that the testator make a will, yeah, in front of a witness, isn't it? If I may see the question again, because I need to read the question, yeah, so that I can, share my idea. Where's the question just now, Encik Anwar? The
Wait, we gonna, oh yeah, it's been already.
If I may read the question, say 40% of the oral will, meaning to say, yeah, he did not hear, yeah, the 100% about the will. Then the testator and his friend, yeah, the testator, the soldiers in actual military service, and his friend, yeah, A, died, yeah, in service. Meaning to say the witness also died. So B only made to make out 40% of the oral will, yeah. What will happen to the rest of his property, yeah? Okay, now the question is, there are two issues here. What will happen to the oral will, and what will happen to the rest of the testator's property? Okay, if this is a situation, yeah, if there is a witness, yeah, who can testify that the testator in actual military service has made a will, yeah, he may tell the War Department about this oral will made by the soldiers, yeah, or made by the soldiers in actual military service. It can be considered, yeah, also a will, yeah. It is privileged if the court find that the testator, yeah, has an intention to dispose his property. Say, for example, yeah, the soldiers here, he has 10 pieces of land. He only say, yeah, he only give or dispose of 4 types of his land to the beneficiary. The rest, the other 6 types of property, may be left as intestate. Yeah. So on how to administer this type of estate, yeah, for the privilege will, we find that, yeah, if this is a real situation, what the applicant can do, yeah, they can the applicant, yeah, the beneficiary may file an application, yeah, of a privilege will with application for letter of administration with privilege will annex. Meaning to say, yeah, they can file, yeah, application for letter of administration, but they can include, yeah, they can include, for example, yeah, if the will is made orally, there is no written will, what they can do, yeah, in the application of letter of administration of privilege wills, yeah, the the witness just now, yeah, the surviving witness, he can affirm an affidavit, yeah, to satisfy the court that he heard the testator dispose his property by oral will. So yeah, this come to the procedure, yeah, on how to administer the estate, yeah, in the case of privilege will. So I have relayed these facts of the case, yeah, with the procedure laid down under the Rules of Court 2012, yeah. That is, you may find, yeah, the procedure under Order 71, yeah, of the Rules of Court 2012. That will be my answer, yeah, briefly on the questions. I hope I
Right.
have answered the question.
Thank you, Doctor. I think Doctor has answered. Yeah, Lily, from Lily, you can comment down if Doctor has answered. Very detailed, very good. Are you still there, Lily? Lily Niche, right? Mm. So can we answer one more question, Doctor, from the comment
Yes,
section?
yes. Yeah,
All right.
inshallah. Please.
Shima, can you pin the next question? Oh, this is the question from Mr. Azni Arifin. The question is, I believe in current situation, the MAF personnel must be in active service as defined in Section 3 of Armed Forces Act 1972. For example, when the soldiers were deployed to Lebanon.
Yes, yes.
Doctor, what do you think?
Yeah. The personnel, yeah, military army personnel, yeah. So Miss Azni, yeah, asked this giving her opinion on this, yeah, under Section 3 of the Armed Forces Act 1972, yeah. For example, a soldier, yeah, has been deployed to another country, yeah, for example, in Lebanon. This is a example where a soldier, yeah, is, we say, yeah, under the law, a soldier is under the position of actual military service. So exactly, yeah, because in my thesis also I have found, yeah, from my research, that the Armed Forces Act 1972 is silence on the provision of law on privilege will. As such, yeah, it is recommended the government, yeah, should take an initiative, yeah, to include this provision of privilege will in the Armed Forces Act 1972 of the Malaysian statute, yeah, governing these soldiers and men, soldiers and airmen, yeah, including members of the naval forces of Malaysia. Yes, this is the example on soldiers in actual military service. Exactly. Any more question?
We can add one more, Doctor. One
Yeah,
more
yeah.
question.
We have time, isn't it? We have
Baru,
about 6 minutes. Yeah.
yeah. Lily already comment. She said yes, a very clear explanation. Thank you,
Yeah, yeah.
Doctor. By Lily. Okay. Anwar, can you read the next question?
Alright, the next question come from Ahmad Shami Anwar. Okay, the question sounds like, does training include in the definition of the actual military service? Alright.
Yes, this is also, yeah, is a very interesting point. Yeah, we may find this answer if we go through the decided cases. Yeah, I cannot remember on the spot the name of the decided cases, but from the case study, yeah, case study that I've done, the court held that, yeah, the definition of actual military service, yeah, include the person who is under the training. Yeah. So like for example, yeah, they are in the training. Kalau dalam bahasa Melayu, ya, pelatih, sedang berlatih kan, pelatih tentera, they are also fall under the category of actual military service. If later, ya, siapa, Encik Ahmad, if you want to know in detail, ya, I think, ya, you can, go through the decided cases, or you can contact me outside this time and ask for the name of the cases. Exactly, yeah, yes.
Yeah. Ahmad Shami is one of our batchmate, Doctor.
Yeah, okay, very good.
Okay. Do we have any
Some
other
of you,
question?
you may apply to become a soldiers, yeah. So also you may also apply for the position to become the members of the naval forces, yeah. Okay, also become the army, yeah. Airman, ya, boleh mohon lah, ya. Macam Encik Anwar, ya, kami nak jadi tentera kan, boleh, ya. Because they are the
Anwar,
heroes
what
for
about
our
you?
countries.
Sure.
Yeah.
Alright,
You also may apply, ya.
Okay, can.
okay, Director. May I ask a question for you?
Yeah, yes.
Okay, regarding these privilege wills, does it include to non-Muslim and Muslim? That is my
Yeah,
question. Does it?
okay. Okay, exactly. To answer this question, yeah, as I have mentioned earlier, our discussion is about privilege wills under the Wills Act 1959. If you look at the Section 2 of the Wills Act 1959, Section 2, Sub 2, yeah, of the Wills Act 1959, we are that the statutes, yeah, the Wills Act 1959 expressly stated that this act is not applicable, yeah. This act shall not apply to the wills of a person professing the religion of Islam. So but now the answer is that only non-Muslim, yeah, soldiers, non-Muslim sailors, non-Muslim mariners can make a privilege will, yeah. However, yeah, if I've also in my thesis, yeah, try to look at the provision of Wills Act, yeah, under the Islamic state, yeah, enacted by the Islamic government, will by way of oral. So as such, this is very, we may come to the conclusion, the Muslim soldiers, Muslim sailors, Muslim mariners and seamen, they are already privileged. So this is the beauty of making a will under the Islamic law. So as such, in my thesis also, I have recommended that the Muslim soldiers, airmen and sailors, they may also be given the provision, a specific provision for privilege will, because they are already privileged under the Islamic law. So that is one of the recommendation in my thesis last time. So it's very interesting, this question. And if you want to know in detail, I've also written 3 papers so far with my supervisor, that is Associate Professor Dr. Associate Professor Muhammad Hisham Muhammad Kamal, Associate Professor Akmal Hidayah Halim, and Assistant Professor Dr. Tajul Aris. So we wrote a paper on this point. So you may contact me later for the detail of the information about this Muslim and non-Muslim soldiers, and also about the point on privilege will. Yes, that is my answer to your question.
All right, thank you, Doctor. That's really answering my question, because I will ask, what is your point of view regarding this matter? Should Muslims should be included in the privilege will? As we know, in Malaysia, the armed forces majority is Muslim, so I hope they got their rights in these privilege wills. Okay. I think that's all from me. Mia, do you have any question?
No, I think we have answered a lot of questions, but do we still have more questions on the comment section? I think that's all, right?
That's all.
Yep, I think that's all. Anwar?
That's all right. Ladies and gentlemen, it seems that we are at the end of the session. We are streaming for about 60 minutes. I'm afraid that this is the end of our discussion for this evening. We would like to express our utmost gratitude and thanks to Dr. Faridah for her willingness to spend time with us, sharing knowledge regarding privilege wills. Thank you for taking time out of your busy schedule and accept our invitation this evening. Your valuable insights are such eye-opening, and the discussion is plenty of food of thought.
Yes, Anna, that is very true. We really hope what Dr. Faridah shared to us tonight will benefit everyone tonight who joined us about our topic of privileged wills. Thank you once again, Dr. Faridah, and of course, thank you everyone who joined us tonight and support our live session tonight. On behalf of Shima Shana and Co. of Group 9 team, we would like to thank you and sorry for any flaws in this event. We wish you safe, and that's all for us. But wait, to the audience, you may stay for a while because we have some activity later, which is small quiz by Kahoot. So you guys can just sit back and to win prizes for